The incessant wars between Lands Cabinet Secretary Charity Ngilu and National Lands Commission Chair Ngilu-Swazuri over who was usurping the other's mandate prompted the Commission to seek a constitutional interpretation from the Supreme Court in April this year. It is a row that stalled transactions over land leases and renewals, including management of private land in the country. In its verdict today, the Supreme Court gave the two parties 90 days to iron their differences, failure to which it would adjudicate. But this reconciliation may be elusive given the unrelenting stance adopted by Ngilu, who on the material day of the ruling used the dailies to lash out at the NLC over its dismissal of leases and titles issued by the registrar. Ngilu maintained that all matters title deeds are the exclusive mandate of the Ministry of Lands and further accused the Commission of encroaching on the functions of a ministry, hence failing to deliver on its core functions. But Land Expert Mwenda Makathimo says both Ngilu and the Lands Commission are acting rogue since the Constitution intended that they be interdependent for the sake of transparency in land matters.
In the spirit of reform, the design was to make sure that none of the two institutions has exclusive control. Because the previous history of offices under the Ministry of Lands is a history that displayed abuse.
A look at Section 110 of the Lands Act, the Cabinet Secretary has powers over land matters to the extent of establishing registries, while Article 6 and 7 of the same Act places land registries under the National Lands Commission. Article 11 and 35 give the registrar the role of signing titles and in fact recognizes his signature as evidence enough to ownership of land.
Areas of law that are contradictory that we have cited on the Land Registration Act, they need to be amended by the Parliamentary Committee on Lands. And these ones can be done in 2 weeks.
Makathimo also says the National Lands Commission should not control registries and the processing of title deeds since the Constitution intended that it oversights the Ministry of Lands. Amidst the tough wars pitting the National Lands Commission and the Ministry of Lands lies questions on the validity of the laws implemented in Kenya, their anticipatory nature, and perhaps the probability by the two players to cede ground, at least for sobriety. But with all these issues, the ball lies at somebody's court. Over to you, Mr. President, and the Parliamentary Lands Committee. John Jacob Curia, Channel 1 News Hour.